A federal judge just issued an order that legal experts are calling one of the most consequential rulings in Trump's entire legal saga. District Court Judge Altha Morrison delivered a 47-page decision demanding Trump's legal team hand over communications, financial records, and internal strategy documents they've been shielding for nearly 8 months. And this isn't some routine discovery dispute or procedural formality. This is a direct judicial rebuke triggered by mounting evidence that Trump's attorneys may have actively misled the court about document preservation and compliance. When a federal judge uses language like troubling inconsistencies and insufficient candor in an evidentiary ruling, you know something catastrophic just landed in the legal record. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what set off this extraordinary judicial action? According to court filings unsealed on February 2nd, prosecutors presented evidence suggesting Trump's legal team provided materially false statements about their document search protocols and may have destroyed evidence after receiving preservation orders. This isn't just another legal setback or tactical defeat. Judge Morrison's ruling strips away attorney-client privilege protections for specific communications, a nuclear option in federal litigation. And believe me, when federal judges start piercing privilege shields, citing the crime fraud exception, you know something enormous has just detonated in the case. Here's the full picture of what's been unfolding. Tensions between Judge Morrison and Trump's defense team have been building since June 2025, fueled by repeated deadline extensions, incomplete document productions, and what the judge described in earlier hearings as a pattern of non-responsiveness. But everything escalated on January 18th when federal prosecutors filed a 127-page emergency motion presenting forensic analysis of Trump's document management systems. The filing, which included sworn declarations from 3 digital forensics experts, alleged that Trump's legal team deleted approximately 2,247 emails and encrypted files between March 15th and March 22nd, precisely 1 week after receiving the court's formal preservation order. This wasn't about standard litigation tactics or aggressive legal maneuvering. It was about potential obstruction of justice through evidence destruction. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Morrison reviewed the forensic evidence in chambers on January 24th, she immediately ordered Trump's attorneys to appear for a sealed hearing. Legal observers who monitor federal court dockets noted that sealed evidentiary hearings are extraordinarily rare in civil litigation, typically reserved for cases where the court suspects criminal conduct or severe ethical violations. And let's be honest for a moment. Federal judges ordering INC camera inspections of attorney conduct is not normal procedure. It doesn't happen over routine discovery disputes or scheduling disagreements. It happens when the court has genuine concerns about potential fraud on the tribunal. Here's what multiple sources familiar with the proceedings say happened next. On January 29th, a 3-hour sealed hearing took place in Judge Morrison's courtroom with only Trump's lead attorneys, federal prosecutors, and a court-appointed special master present. No transcripts were released, but sources told CNN that Judge Morrison spent the first 90 minutes questioning Trump's attorneys directly about inconsistencies between their sworn declarations and the forensic evidence. One attorney who spoke on background to the Washington Post said the judge's questions were surgical and relentless, focusing on a 72-hour window in March when server logs showed bulk file deletions occurring from IP addresses linked to Trump's legal team's network. Meanwhile, Trump's lead counsel, Christopher Casey, reportedly attempted to invoke attorney work product protections, arguing that internal legal strategy communications should remain shielded. By the end of that session, Judge Morrison had made clear she was unconvinced. The ruling, released 5 days later on February 3rd, spans 47 pages and methodically dismantles Trump's privilege claims for 38 specific categories of documents. The language is unusually direct for a federal court opinion. Judge Morrison writes that the evidence presented by the government establishes a reasonable likelihood that attorney-client communications were made in furtherance of ongoing or planned criminal conduct, thereby falling squarely within the crime fraud exception to privilege protections. Drop a comment right now if you saw this coming. I read every single one. Now, things get absolutely explosive. The court didn't stop at ordering document production. Judge Morrison imposed sanctions requiring Trump's legal team to certify under penalty of perjury that no additional evidence has been destroyed and to provide complete forensic images of all servers, backup systems, and cloud storage accounts used since January 2025. Legal analysts immediately recognized this as judicial skepticism elevated to formal finding. When a federal judge requires attorneys to make sworn certifications about evidence preservation after finding privilege exceptions, it signals the court has concluded previous representations were materially false. That's when it became clear this isn't just another discovery battle. The bombshell moment came when legal reporters obtained the full text of Judge Morrison's ruling and highlighted a footnote on page 34. In measured but devastating language, the judge noted that if prosecutors' allegations are substantiated through the ordered disclosures, referrals to state bar disciplinary authorities and the Department of Justice would be not only appropriate, but necessary to protect the integrity of these proceedings. This move sent shockwaves through legal Twitter and cable news legal panels. When a federal judge publicly contemplates bar referrals and DOJ investigation of a defendant's attorneys, it signals one thing. The court believes it may be witnessing obstruction unfolding in real time, and institutional safeguards require intervention. This isn't the first time mounting evidence has forced courts to pierce attorney-client privilege protections in Trump-related cases. Think back to March 2024, when Judge Barl Howell ordered Trump's then-attorney Evan Corcoran to testify before a grand jury investigating classified documents at Mar-a-Lago. Prosecutors successfully argued the crime-fraud exception applied because evidence suggested Corcoran was being used to further obstruction. Corcoran's testimony proved devastating, providing contemporaneous notes documenting Trump's instructions that contradicted his public claims. Then there was the parallel situation with Rudy Giuliani in the Georgia election interference case. When Fulton County prosecutors presented evidence that Giuliani's legal advice to Trump may have been in service of criminal election subversion, courts similarly stripped privilege protections for key communications. The pattern in that case showed how attorney involvement doesn't immunize conduct when the legal work itself furthers unlawful objectives. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the earlier New York civil fraud trial, where Judge Arthur Engoron repeatedly sanctioned Trump's legal team for what he characterized as dilatory tactics and misrepresentations about document completeness. In that case, financial records that Trump's team initially claimed didn't exist were later discovered in storage facilities, leading to adverse inferences and credibility findings that devastated Trump's defense. Now, however, the stakes are different. This time, we're not dealing with civil fraud, liability, or state-level prosecutions. This federal case could expose Trump to charges carrying decades of imprisonment, and his legal team's conduct is now under a federal microscope. The pattern is clear. When courts conclude Trump's attorneys are being used as instruments of obstruction rather than advocates operating within ethical bounds, even the most robust privilege protections collapse. So what exactly triggered this extraordinary judicial intervention? According to cybersecurity and legal ethics experts who reviewed the unsealed portions of prosecutors' forensic analysis, the evidence reveals a systematic pattern of evidence manipulation that goes far beyond negligent document management. The forensic reports detail metadata timestamps showing 2,147 files were batch deleted on March 19th at 2:47 a.m. from servers located at a Virginia facility used by Trump's legal operations. These weren't random deletions occurring over time. They were concentrated bulk removals executed during a narrow window using administrator-level credentials. Here's the kicker. The deleted files included email threads between Trump and his attorneys discussing document retention strategies, drafts of legal filings that were never submitted to the court, and financial records related to payments Trump made to witnesses who later refused to cooperate with investigators. This wasn't about privileged legal strategy that deserved protection. According to the forensic analysis, it was evidence of deliberate concealment of materials directly responsive to outstanding subpoenas. Don't go anywhere. The most explosive part is coming next, and here's what should alarm everyone. This isn't just about one set of deleted files or one episode of questionable conduct. If Trump's legal team can systematically destroy subpoenaed evidence while claiming attorney-client privilege as a shield, the entire framework of criminal discovery and judicial oversight becomes meaningless. Once courts lose the ability to enforce compliance because evidence simply vanishes behind privilege claims, there's no mechanism left to ensure defendants can't obstruct their own prosecutions with impunity. This puts Trump's remaining legal team in a nearly impossible position. On one side, they face intense pressure from Trump himself to mount maximum resistance, delay every proceeding, and never concede an inch of ground regardless of the legal merits. That means continuing to fight disclosure, attacking the forensic evidence as unreliable, and framing Judge Morrison's ruling as politically motivated overreach by an Obama appointee. On the other side, these attorneys now must reckon with a federal judge who has publicly questioned their candor, imposed certification requirements under penalty of perjury, and explicitly raised the prospect of bar discipline and DOJ criminal investigation. They have to decide whether protecting their clients' immediate interests is worth risking their law licenses and potential prosecution for obstruction. And here's the tricky part. There's no credible defense that satisfies both imperatives. Either they comply fully with Judge Morrison's order and provide the documents, which almost certainly contain evidence damaging to Trump's position, or they continue resisting and risk contempt, citations, personal sanctions, and the professional destruction that comes when federal judges conclude attorneys are acting in bad faith. Legal and political analysts are calling this a turning point that fundamentally alters the trajectory of Trump's federal prosecution. Barbara McWade, former U.S. Attorney for the Eastern District of Michigan and current University of Michigan law professor, told MSNBC that Judge Morrison's ruling represents one of the most significant victories for prosecutors in the entire case. She explained that piercing attorney-client privilege is extraordinarily difficult and signals the judge has concluded there's substantial evidence of criminal conduct facilitated through attorney-client communications. A former federal prosecutor who handled white-collar cases for 15 years added that these kinds of rulings typically precede major plea negotiations or superseding indictments. When courts force defendants to disclose attorney communications under the crime fraud exception, it often means prosecutors are building obstruction charges, and the disclosed materials provide the final evidentiary pieces. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Andrew McCarthy, a conservative legal commentator and former assistant U.S. attorney who often defends broad executive power, acknowledged that the forensic evidence of bulk deletions occurring immediately after preservation orders is extremely damaging. He emphasized that while defendants have robust rights to mount aggressive defenses, those rights don't include destroying evidence or using attorneys as instruments to facilitate obstruction. The constitutional protections for attorney-client privilege exist to enable effective legal representation, not to provide cover for ongoing criminal conduct. So, let's break down what this could mean. First, the immediate legal impact is enormous. Trump's legal team now has until February 24th to produce all documents identified in Judge Morrison's order, certified under oath as complete and accurate. This includes attorney-client communications the court has determined fall within the crime fraud exception, financial records Trump has fought to keep secret for years, and forensic images of computer systems that may reveal additional evidence of document destruction. Legal experts expect these disclosures to provide prosecutors with devastating ammunition for both the underlying charges and potential new obstruction counts. Second, it creates massive credibility problems that will infect every aspect of Trump's defense going forward. When a federal judge makes formal findings that a defendant's attorneys provided materially false information about evidence preservation, that finding becomes part of the permanent record. Every future motion, every privilege claim, every factual representation Trump's team makes will now be evaluated through the lens of a court that has already concluded their prior statements lacked candor. Judge Morrison's ruling essentially strips Trump's legal team of the credibility presumption attorneys typically enjoy. Finally, the political implications ripple far beyond the courtroom. Every Republican candidate and elected official will now face questions about supporting someone whose own attorneys stand accused by a federal judge of potentially criminal conduct in service of obstruction. Campaign opponents are already circulating clips of the ruling's harshest language. This creates a narrative problem Trump can't easily spin away because the allegations come not from partisan prosecutors or media critics, but from a federal judge's formal written opinion backed by forensic evidence. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective, but beyond the immediate legal and political consequences, this ruling is really about fundamental principles of equal justice and the rule of law. The attorney-client privilege exists as a bedrock protection in our adversarial system, enabling defendants to obtain candid legal advice without fear that confidential communications will be used against them. It's essential for fairness and constitutional due process. But that privilege is not absolute, and it was never intended to shield criminal conduct. When attorneys become participants in obstruction rather than advocates operating within legal and ethical bounds, courts must have the power to intervene. If defendants could destroy evidence with impunity by routing their obstruction through attorneys and then claiming everything is privileged, the entire criminal justice system would collapse. This scenario is causing absolute panic within what remains of Trump's legal operation. Reports indicate senior attorneys held emergency conference calls on February 4th to assess their options and exposure. Some reportedly argued for immediate compliance with Judge Morrison's order, recognizing that further resistance would only deepen their legal jeopardy. Others insisted Trump would never accept full disclosure and that any attorney recommending compliance would be fired immediately. The team is fracturing in real time, caught between a client who demands total resistance and a federal judge who has made clear she will not tolerate further obstruction. Meanwhile, Trump's core supporters are furious at what they perceive as yet another example of judicial overreach and weaponization of the legal system. Social media channels exploded with claims that Judge Morrison is a partisan hack doing the Biden administration's bidding and that the entire forensic evidence presentation is fabricated. Trump himself responded on February 5th with a series of Truth Social posts, calling the ruling a complete and total witch hunt, and claiming the deleted files were merely routine housekeeping unrelated to any subpoenas. He specifically attacked Judge Morrison as a radical Obama judge who should have recused herself years ago and promised to appeal the ruling immediately. Stay with me. What comes next will completely change how you view the situation. Here's what makes this even more devastating for Trump's position. His public response to Judge Morrison's ruling essentially confirms prosecutors' core allegation. Instead of providing any innocent explanation for why thousands of files were deleted 1 week after receiving a preservation order, Trump's defense amounts to attacking the judge's motives and dismissing the forensic evidence as fabricated. When your response to documented evidence of bulk deletions is claiming the judge is biased rather than explaining what was deleted and why, you've already conceded you have no legitimate justification. Legal experts immediately recognize the strategic disaster. Former federal judge Nancy Gertner told CNN that Trump's public attacks on Judge Morrison could trigger additional sanctions and virtually guarantee any appellate court will defer to her factual findings. She noted that when defendants publicly accuse federal judges of corruption while refusing to provide substantive responses to evidence, appellate courts read that as confirmation, the lower court's skepticism was justified. This goes far beyond one evidentiary ruling in one criminal case. It's about whether any defendant, regardless of wealth or political power, can systematically destroy evidence, mislead courts about compliance, and then hide behind privilege claims to avoid accountability. If there are no consequences when attorneys facilitate evidence destruction by deleting thousands of subpoenaed files and then claim everything is protected work product, it means defendants with sophisticated legal resources can effectively immunize themselves from prosecution. Once that precedent is established, the entire premise that no one is above the law becomes an empty platitude. It's not just about Trump. It's about whether our criminal justice system retains the capacity to investigate and prosecute powerful defendants who can afford attorneys willing to push ethical boundaries. If this blows your mind, hit that like button right now. Here's the situation. A federal judge has formally ruled that Trump's legal team likely engaged in criminal conduct by destroying evidence and making false statements to the court. The ruling strips privilege protections from dozens of categories of documents and communications, requires certified production under oath by February 24th, and explicitly contemplates referring Trump's attorneys to bar authorities and the Department of Justice for investigation. This is no longer just about the underlying criminal charges Trump faces. It's now about whether his own legal team will face prosecution for obstruction and whether Trump himself can be charged with directing that obstruction. When federal judges issue rulings this devastating and use language this severe, we've entered territory where the legal system is defending its own integrity. If there are no consequences, it establishes a blueprint for wealthy defendants to obstruct investigations by rooting evidence destruction through lawyers and claiming privilege. Keep a close eye on the February 24th deadline for document production. Multiple legal analysts expect Trump's team will attempt to appeal Judge Morrison's ruling to delay compliance, but appellate courts rarely overturn evidentiary rulings absent clear abuse of discretion. More importantly, watch for signs that prosecutors are preparing a superseding indictment adding obstruction charges based on the evidence destruction. Legal experts note that the forensic evidence of bulk deletions combined with false statements to the court provides the foundation for additional felony counts carrying substantial prison time, and former federal prosecutors are watching to see whether individual attorneys face personal criminal liability for their roles in the alleged evidence destruction. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. A federal judge just delivered a 47-page ruling concluding that Trump's legal team likely committed crimes by destroying evidence and lying to the court. Trump's attorneys have 3 weeks to produce documents they fought for months to keep secret certified under penalty of perjury. Meanwhile, the same judge who issued this devastating ruling has explicitly raised the possibility of criminal and disciplinary referrals for the attorneys themselves. This isn't just another legal setback that Trump can appeal away or dismiss as partisan persecution. This is a federal judge formally finding that Trump's own lawyers may be criminals who use their positions to facilitate obstruction. What happens next could determine whether attorney-client privilege retains any meaning as a protection for legitimate legal representation or becomes a tool for wealthy defendants to obstruct justice with impunity. The evidence is documented in forensic reports. The ruling is entered in the permanent court record. Now, we wait to see if Trump's legal team complies with the February 24th deadline or doubles down on resistance and faces contempt. We wait to see if prosecutors file obstruction charges based on the evidence destruction. And we wait to see whether individual attorneys face personal criminal prosecution for their alleged roles in deleting thousands of subpoenaed files. The stakes have never been higher. The evidence has never been more documented and specific, and the judicial reckoning has never been more immediate.